Good morning, Colorado. This is the Colorado Energy and Carbon Management Commission. It is October 4th. It is 9 a.m. We will recognize our existence with a roll call. And doing the roll call this morning, I'm pleased to announce, is our newly appointed hearings manager, Mr. Elias Thomas. Welcome, Elias, and thank you for doing the roll call and being with us. We look forward to working with you into the future.
Thank you very much. Likewise. Commissioner Ackerman?
Here.
Commissioner Cross?
Present.
Commissioner McGowan?
Here.
Commissioner Mesner?
Here.
Commissioner Hess? Commissioner Murray?
Here.
Commissioner Robbins?
Here.
Mr. Chair, you have 6 of 7 commissioners present.
Excellent. Excellent job doing the roll call there. So thank you. All right, commissioners, first on our agenda is commissioner comments. Does any commissioner have comments for any of us and or the state and or the work that we're doing? Seeing no comments, we move to consent agenda. Does any commissioner have questions with regard to consent? Seeing none, do we have a motion to approve consent?
So moved.
Second.
Motion and a second to approve consent. Any further discussion? Seeing none, all those in favor signify by saying aye. Aye. Motion passes. Don't see any no's. All right, now
Is Commissioner Mesner frozen on anyone else's screen except for me? Oh,
actually he's so frozen he's gone. Let's give Commissioner Mesner a second to perhaps rejoin with us. Commissioner Mesner is working on getting reconnected. Give us a second here. Maybe a minute or so. AG Davenport, are you with us? Maybe we can fill the void here with some procedural matters.
Yes, Chair.
So we have 2 dockets. We've got a enforcement matter ending in 217 and then a payment of proceeds ending in 088. And from review of the record, it appears that these are pending before us, but we don't have oral argument or other presentations scheduled for either. First off, is my understanding correct on that front?
Yes.
Okay. So what's the order of play?
Well,
Just procedural matter. I mean, do we, I know we've got lawyers available for questions if we have any. Are we basically trying to determine whether we're going to approve the hearing officer's recommended order in each and or within any modifications there too?
yes, that's accurate. So the first matter on my schedule is the enforcement matter. There is an AOC to which a complainant has brought an exception. There, the commission's decision is whether or not to approve that AOC over the exception or not. Second is a payment of proceeds matter where there is a hearing officer recommendation. Party has filed an exception to that recommended order and has requested modifications to that. And the decision point for the commission is whether or not to grant those modifications or make any other changes.
Okay. Thank you. Does anybody have, since we're filling the void of giving Commissioner Mesner a chance to get back on board, anybody have any further procedural questions for AG Davenport or for ourselves as a whole?
Sure.
Hey, Commissioner Mesner, we hear you.
So I'm here. I'm going to leave my video off because I had to use a hotspot in order to rejoin, and so I'll keep my video off until I can sort out my regular internet.
Awesome. All right. Let the record reflect that we have Commissioner Mesner back with us. We have a quorum of 6 out of 7 commissioners. We've approved consent agenda. We will move now into docket 2208-00217. This is an enforcement matter. As was noted by AG Davenport, there is an administrative order of consent pending before us. There is an exception that's been filed to that. And the question for the commission is, do we approve the administrative order or do we take up the exception? I believe we've got lawyers from all sides available if we have questions. Does anybody desire to start out with thoughts, deliberations, etc. on docket 2208-00217. Commissioner Ackerman?
Thanks, Mr. Chair. I just note that the record is quite clear and appreciate the provision of those documents to the commission for our review. I do have one question, if that's appropriate, Mr. Chair.
It is.
Thank you. And I think this is probably to staff. And I just wanted to say that, acknowledging that it's not the place of the director or the commission to address civil liabilities, it was unclear to me from the record whether there had eventually been any resolution in compensation for lost and damaged cattle and damaged land on this matter. Do we have an answer to that question?
Thank you, Commissioner Ackerman. Unfortunately, while you were asking the question, I was being promoted to a panelist, and I missed most of it. My
Thanks.
apologies.
Thank you, Councilor Boudreau. That's a common occurrence, so no worries at all. I just wanted to reinforce that I recognize that it's not the place of the director or the commission to address civil liabilities in this matter, but it was unclear to me from the record whether there had been any resolution in compensation for lost and damaged cattle and damaged property for this landowner. Do we know if there's been a resolution or if that's pending somewhere else?
To the best of my knowledge, there may be a civil suit. I think either Mr. O'Toole or Mr. Hefner would be able to address that better than I could. There's been no resolution to the cattle issue as far as staff is concerned. I believe there was no surface owner protection bond in place that would have covered the cattle. And as you noted, the commission doesn't have jurisdiction to resolve private disputes among parties. But I think the last time we were here, at the time when the commission approved this AOC, I believe the parties, Western and K&T, indicated that there was either a pending civil suit or there would be one soon.
Thank you, Councilor. And Mr. Chair, if it's appropriate for other council to comment and update us on that, it would be helpful for me to understand where that lies, once again, recognizing that can't be part of our decision here today.
I see that we have a Mr. Hoffner that has elevated himself. Good morning.
Hi, good morning, Commissioners. I can speak briefly to this question, and the answer is there is a civil case that has been filed in state court. At this point, it is pending and unresolved and, headed down the tracks toward trial.
Thank you for that response. Mr. Chair, I do have some deliberative comments, but I'll hold those pending any other questions.
Any other questions from commissioners? Lay it on us with your deliberative thoughts, Commissioner Ackerman. Mr. O'Toole, did you desire to respond to that question?
There is a lawsuit pending in Kiowa County. It is set for trial in April. There will be a resolution of the cattle and land value issues along with liability at that time. So it is processing through the ordinary course.
Okay, thank you for that further clarification from your perspective. We appreciate it. Commissioner Ackerman, did you want to provide some deliberative thoughts?
I will, Mr. Chair. Thank you, and they will be very brief. I do appreciate once again, the thoroughness of the record and the ability to review those documents. And I wanted to say I do recognize that the maximum potential penalties were not assessed in this matter. I do recognize that it's not uncommon in an enforcement context for there to be a potential range of actions and penalties available to the director, depending on the circumstances, evidentiary record, and the record in general, and the facts associated with each case. I do find that in the enforcement action and the assessed penalties resultant from these violations, the director appropriately exercised prudent discretion within the bounds of our regulations. And it's my opinion that there is not a clear error in judgment here by the director in the penalties that were assessed, and support the order as previously issued, Mr. Chair. And that's all I have for deliberative comments.
Appreciate that. I'm pretty much in agreement with those thoughts and comments, Commissioner Ackerman. Other commissioners with thoughts or comments or deliberations? Do we have a motion?
Mr. Chair, I'll make a motion. I'm not quite sure the context of the motion, though, whether it's a motion to support the order as issued or a motion to dismiss this matter. Can the counselor help me with that?
AG Davenport,
Thanks, Chair and Commissioner Ackerman. I think a motion to approve the AOC as presented would be sufficient in this case.
Thank you, counselor. So moved, Mr. Chair.
Second.
motion from Commissioner Ackerman to approve the AOC, a second from Commissioner Cross. Is there further discussion on the motion? Seeing no further discussion, is all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries unanimously. Thank you for that. We will now move to the second and final piece of our agenda for this Wednesday morning. I would note we do have a high priority habitat rulemaking scheduled for tomorrow at 9 a.m. The docket that we'll take up now is 2204-00088. This is a payment of proceeds matter.
Mr. Chair, you got a commissioner that's wanting to comment, and then AG Boudreau has been raising his hand.
Oh, sorry. I was looking down at my pieces of paper. Commissioner McGowan.
Thank you, Mr. Chair. After, reading this about this issue for a second time, as a commissioner, I would be curious to understand what a surface owner bond covers or does not cover sometime in the future. It was interesting to me that we don't have a remedy when something like this happens. And it wasn't clear to me that if under the new rules and financial assurance and surface owner bond issues, whether this will be covered in the future or if it just simply isn't covered and we don't have the authority. Not for discussion for today, but I would be interested in discussing that as a commission.
Great. Consider that direction to the director and staff to get back to us with a short presentation along those lines so that we can get some perspective, especially with regard to the new financial assurance rules and the upping of the surface owner protection bond. Seeing nothing further on that point, I do recognize AG Boudreau.
Thank you, Mr. Chair. And I don't mean to get too deep into the minutia, but I wonder if, because the exception was filed by K&T, if maybe the motion is to deny the exception as opposed to approve the AOC, which the commission's previously done in the last time this went before the commission.
AG Davenport, we have dueling AAG opinions at this point. Which way would you like us to go? We can.
That was not my intent. Sorry.
Sorry, I was muted. No, I understand the issue. I think if the commission would like to clarify that in approving the AOC, there's also a denial of the exception. That's fine as well. My opinion was by approving the AOC over the exception was implicitly denied as well. But if the commission would like to at this point clarify that by approving the AOC, they've also denied the exception, that's fine too.
Well, let's do and both. I'll move to deny the exception.
I'll second.
Motion and a second to clarify the record to ensure that there are no implicit denials and that we have express denials. All those in favor of the motion to deny the exception signify by saying aye. Aye. Any opposed? Does that cover it, AG Boudreau?
Yes, thank you, Mr. Chair. And again, I don't mean to get too far into the minutia. I just wanted to make sure we got all the I's dotted and T's crossed.
And all the lawyers happy. Awesome. Okay, anything further? Mr. Hearings Manager Thomas, I see you're with us, or did you have anything further? Or am I allowed to move to the next topic?
Not on this matter. Thank you.
Okay, great. All right, then let's take up 2204-00088. A payment of proceeds matter. Again, we do not have oral argument. There is a recommended order, and I think it's before us to deliberate whether to approve it or not, or adjust it. I also note that I think that the parties were going to be available from 9:30 to 11. And so Hearings Manager Thomas, would it be appropriate to take about a 13-minute break to let the parties be available at those appropriate times?
It actually appears that all the attorneys are available now. They were all attendees. So I believe we should be ready to go. They've all been promoted and are prepared for any questions the commission might have. So I think we can start now.
Oh, okay. Excellent. Then with that, commissioners, we have before us the pleadings in this case. We have availability of counsel if there are questions from folks. So I would turn to my fellow commissioners to first ask if anyone has questions that they would like to provide to any of the attorneys in this case. All right, seeing no questions, we can move to deliberations. Does anyone desire to deliberate on this matter? And I can actually throw it out there. Or Commissioner Cross, do you desire to?
Sure. If you want to start off, Chair, I'm more than happy to let you start off, and I can provide my thoughts afterwards.
I don't know. It just seems to me that the central issue is there is not disagreement that the hearing officer's conclusion was reasonable based upon the pleadings. It does not appear that there's disagreement that we don't have jurisdiction because this is a contractual dispute. And then in my mind, we may want to consider amending the order, but just to clarify that we're not deciding the leases are silent on post-production costs. That's a contract dispute. And I just basically, I think we're clear that we don't have jurisdiction over this matter given the airport lands case. Commissioner Cross?
Thank you, Mr. Chair. And I agree with that. And I think it is prudent to remove the sentences that talk about that. I spent some time going back and going through the initial briefing, as well as the exception briefing. And I do understand the hearing officer's reasoning for putting the information on, because a lot of the briefing was not focused on the silence issue. However, and I'm just trying to pull up the actual part of it now, but there is a line in response to, let me get up I apologize. So the response to the determination, and I think it is somewhat minor, but I think it is important to note. And it specifically states that, and it's on the very first page, it says, but the commission has no authority to make that or any other finding concerning this dispute. And to me, I think that's really where we get to the heart of the matter of removing that language, as opposed to having it go forward and just kind of clarifying that we don't have any jurisdiction. And the reason why is, I think in reading through the hearing officer's recommendation, or the hearing officer's order there, I think there was a note that there wasn't discussion about it being silent. There wasn't really a dispute over that issue. But I think that line that the commission has no authority to make that or any other finding concerning this dispute is essentially saying that there should not be any kind of decision about whether it's silent, whether it's not silent, whether it's ultimately it's disputed. And so the fact that it is disputed, I think, is how it should go forward. There is a dispute. We don't have jurisdiction under the airport land case to make any kind of determination for that. So I would be in favor of removing those lines from the hearing officer's order. I believe you're still muted, Mr. Chair.
Thank you for that. Further thoughts, discussion, deliberation from commissioners? Seeing none, Commissioner Cross, do you want to potentially hazard a motion here?
I would be happy to. I would move to grant the exception, specifically deleting the sentences in the hearing order, the hearing officer's order that states, one, here there is no dispute that noble leases do not contain any provisions permitting or even addressing the deduction of post-production costs. So the implied covenant to market applies. And also the sentence in the recommended order that states, here the leases are silent as to post-production costs. And so the implied covenant of marketability applies.
We have a motion. Do we have a second? Commissioner McGowan?
Sorry, could you clarify that you're recommending removing those two sentences? Okay, thank you. I'll second.
All right, a motion and a second. Is there further discussion?
Mr. Chair.
Yes, AAG Davenport?
I appreciate, I understand the direction that the motion is going. I would suggest that the commission afford me the opportunity to modify or to draft an order of the commission that would essentially be the recommended order with those sentences deleted, and then with some additional amendments just to clarify the commission's decision that it still does not have jurisdiction, and to sort of make the order consistent with the deletion of those sentences. Is that acceptable?
It's fine with me. I'm not the movement or the seconder. What about that, Commissioner Cross?
I'm in favor of that amendment to the motion.
Okay. And do we have the second is in favor of that as well?
Yep, but
Okay.
I would like to clarify, we did already decide in an earlier vote, right, that we didn't have authority over this, and it was a contract dispute. It was an interpretation issue. And we're coming back here for a second time because the parties don't like those two sentences in there. Some of the parties. That was my understanding. We've already actually.
AAG Davenport?
Hearings manager Thomas can correct me if I'm wrong, but I don't believe this has come before the commission. I think that this is an instance where the hearing officer issued a recommended order, and the parties then filed an exception. So is that correct, hearings manager Thomas?
The recommended order did come before the commission.
Okay.
As a matter of procedure, they had the opportunity to stay it on their own motion. Once
you.
that was not done, then the exceptions were filed in accordance with Rule 520.
Okay.
Very
So,
good.
Am I correct that we have already seen this? Okay, I'm not crazy. All right.
You are not crazy, Commissioner McCowan.
So if we need to clarify, I'm fine with that, but I just wanted to make sure that I wasn't going nuts.
All right.
Mr.
AAG
Chair.
Jost, I'm recognizing you. Go ahead.
Thank you so much. My apologies, but I just want to make a clarification. So our request would be to remove the sentences that Commissioner Cross referenced in both the section of Noble leases and Kerr-McGee leases, but also the remaining portions of that paragraph, because after the interpretation is made, there is language that says, much like airport lands, the parties' dispute boils down to the point of marketability. And then on the following page, on page 7, it also talks about that the parties' dispute implicates questions of fact that are tied to the prior sentence. And so in addition to the sentences, we would just like to request that remainder of those paragraphs be struck from the order for clarification, just because they all tie together. And thank you for allowing me that comment.
Thank you for the comment. I believe we still have a motion and a second that does not accommodate that full-on request from Ms. Jost. Commissioner Cross, I note that you're vigorously reviewing your screen. So do you have thoughts after having heard from the attorney?
I think that I don't know that I'd get rid of the remainder of that paragraph. I think if anything, the part of the sentence that says, so it continues, those factual determinations implicate questions of contract interpretation. I think that that's fine staying. I think that bringing up the implied covenant to market or prohibited by the language, I think I'd just keep my motion the way it is. I think that striking the language discussed specifies it, gets rid of the discussion of silent as to post-production costs, and does not make any kind of determination that you have to look to the implied covenant. And so I think I just keep my motion as is.
Very good. And at the end of the day, I mean, we have clarified in the record that we're not making a determination relative to the language of the leases. So, and unless I'm wrong, I think that, that's a judicial determination. And, I think the court's going to take this thing up to de novo, and it's not going to defer to any lackluster comments of commissioners, here on the record today. So I think I'm comfortable with where we are as well. Commissioner McGowan, you had seconded the motion, or do you remain in a level of comfort with regard to where we're at? Okay. Motion and a second, further discussion. Seeing none, all those in favor of the motion signify by saying aye.
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 I think that was 5 ayes. Any opposed? No opposed, so the motion carries unanimously. All right, well, commissioners, we had a sort of a short docket. I think we've muddled our way through it. Tomorrow we will take up docket 2302000062, the high priority habitat rulemaking. That begins at 9 a.m. So we'll have a good day ahead of us tomorrow. Is there anything else before the commission this morning? Commissioner McGowan?
Thank you, Mr. Chair. And I don't know if Deputy Director Larson is still listening in. I just wanted to remind folks that we soon will be taking up public comments related to cumulative impacts. I didn't look this morning, Ms. Larson, to see if we have the link up yet, but I wanted to make sure that people who want to sign up to make comments about our cumulative impacts rulemaking knew where to go and were able to do so. I forgot to do it during commissioner comments.
No, thank you, Commissioner McGowan. And yes, we do have on our homepage under news and notices, a brief description of next week's hearing on the 12th and 13th, and a link to that sign up page.
Great. Everybody jump to your computers and sign up. We want to hear from you. So that's fantastic. And that's a good comment, Commissioner McGowan. I'm glad you raised that. We've got 53 some odd folks that are listening in. So we hope to hear from you next Thursday and Friday. And if you have nothing better to do, jump into the call tomorrow morning at 9 and listen into the high priority habitat rulemaking that we will take up tomorrow morning.
And Chair, just a correction, I believe we're starting at 10 a.m. tomorrow.
Oh,
And
10. Okay.
Hearings manager Thomas can correct me, or Ms. Morrow can correct me, but I'm pretty sure it's 10 tomorrow. Is that correct? Or is that next week? Maybe now I've muddled everything.
Everything currently says 9, but
Okay, I apologize. I should not have spoken. It's next week, next Thursday that we start at 10 a.m., not tomorrow. So
Okay.
you were
So
correct.
again, 9 a.m. tomorrow, high priority habitat rulemaking. Look forward to seeing everybody there. With that, look for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
See you in the morning, guys. Girls.